Hello, everyone, and welcome to One Civil Law. For today's case, we are doing a requested case from one of our channel members who donated $20 in a super chat for me to cover a particular opinion from a U.S. court. And this particular opinion is from the United States Supreme Court case in the case of Rendell Baker versus Cone. This deals with a private school and whether or not this private school is actually a state actor for the purposes of law. A teacher was dismissed. And the question is whether or not she was entitled to due process, because the private school is actually a state actor. So the Supreme Court is getting into the analysis of this and what is or is not a state actor. So that's an interesting issue, because right now there's actually a bit of an issue right now with whether or not Facebook might have recently become a state actor. There has been some suggestion in some of the news reporting on Facebook banning people as it relates to organizing protests relating to the COVID pandemic. And they've been taking down some group meetings and events meetings and banning people from organizing. And there has been a suggestion that this might have been in consultation with various state governments. And then it's a question of what exactly does that mean? Because, it depending on exactly what that means, that might be state action. If a government actor is in particular demanding a private entity do something, it becomes state action for this private entity. So is Facebook violating the First Amendment? Maybe. So we're going to read this case and see if it might inform when someone becomes a state actor or not. So let's get into this. Chief Justice Burger writes this opinion for the Supreme Court saying, "We grant certiorari to decide whether a private school whose income is derived primarily from public sources and which is regulated by the public authority acted under a color of law when it discharged employees." Okay. The school at issue in this case was founded as a private institution and is operated by a board of directors, none of whom are public officials or are chosen by public officials, private entity. When students are referred to this school by various law, the school committees in these cities pay for students' education. So what's going on here is that this is a private school that focuses on special education, special needs education. And so they provide a need that the state government has. So, state government wants to provide education, so they can refer someone to this school, and when that happens, the state pays for them. Fair enough. The school also receives funds from a number of other state and federal agencies. In recent years, public funds have accounted for at least 90%, and in one year, 99% of the budget. So this is ostensibly a private school, ostensibly with private members, but it's funded almost exclusively by state money. So these are special needs, and they're dealing with that, outside the normal school system. They specialize in that. The state's paying for it. Is that enough for it to become state action? The state is referring the students. The state is paying for it. Is that enough for state action? Let's read on. To be eligible for the tuition funding, how they get funded, under the law, the schools must comply with a variety of regulations, many of which are common to other schools. The state has issued detailed regulations concerning matters ranging from record keeping to student-teacher ratios. Concerning personnel policies, the law requires the school to maintain written job descriptions and written statements describing personnel standards and procedures, but they impose few other requirements. So, there's a little bit more here, right? So it's not just we're paying for these to go to these places. We're also telling you a little bit more. We're dictating certain policies, how things are kept, student-teacher ratios, other things. We're requiring you to do certain things in order to get this money. So there's a little bit more. Does that make it state action? Let's read on. When 5 of the 6 petitioners in this case were teachers at the school, the petitioner was a vocational counselor hired under a grant from the Federal Law Enforcement Association, Federal Law Assistant Administration, whose funds are distributed in Massachusetts through State Committee or Criminal Justice. As a condition of the grant, the Committee on Criminal Justice must approve the school's initial hiring decisions. So now we have a little bit more. We have this particular petitioner who comes under virtue of a federal grant, all right? And as one of the conditions of getting the grant, they have to approve that initial hiring decision. So that's a little bit more government intervention. Is that enough for state action? Let's read on. Rendell Baker was discharged by the school, and 5 other petitioners were also discharged. Rendell Baker's discharge resulted from a dispute over the role of student staff council in making hiring decisions. Rendell Baker then advised the board of directors she had been discharged without due process because she exercised her First Amendment rights. So she's critical of this organization within school. She expressed it. She says she was fired as a result. So she says, well, it's a violation of my First Amendment rights. It's retaliation for me engaging in protected speech. Okay. She demanded reinstatement or a hearing. The school agreed to apply a new policy calling for appointment of a grievance committee to consider her claims. Randall Baker also complained to the State Committee on Criminal Justice, which asked the school to provide a written explanation for discharge. So, it was initially hired, and she complains this and says, well, what's up with this? Okay. After the school complied, the committee responded it was satisfied with the explanation, but notified the school that it would not pay any back pay or other damages award that it might obtain as a result of the discharge. Fair enough. So, we're satisfied. This is a good reason. We're not paying for this. Okay. The committee told Randall Baker it had no authority to order a hearing, although it would refuse to approve the hiring of another counsel if the school disregarded its agreement to apply its new grievance procedure in her case. So, fair enough. So it said, we want this particular procedure, and, if you don't do it, we're not going to give you any more money. Okay, fair enough. At that point, the Randall Baker objected to the composition of the grievance committee, and its proceedings never went forward, and filed suit in 1977 under 1983, alleging that they'd been discharged in violation of First, Fifth, and 14th Amendment rights. Okay. First Amendment, freedom of speech, Fifth Amendment, property interest, and 14th Amendment by incorporation. All that stuff makes sense. So they're saying, I was hired as a result of a federal program. The federal person initially appointed me. You're funded almost exclusively by the federal government. So this is actually a state action. This is actually the state acting. And so I'm entitled to protections under state action theory. Okay. The District Court for the District of Massachusetts granted defendant's motion for summary judgment in this suit. A claim may be brought under 1983 only if defendant acted under color of law. Yeah. The District Court took the standard to be whether there is a sufficiently close nexus between the state and the challenged action of the regulation so that the latter may be fairly treated as that of the state itself. Yeah, so that's basically one of the standards you're looking for. A federal or state government cannot hire a third party to do what it can't do directly. So, the classic example is a police department can't hire a private investigator to bust down a door and conduct a search. That's not going to work. That's way too close. So there's a line somewhere where a private actor can become a state actor. And one of the things you look for is a nexus. You look for this closeness of connection. The district court says, I'm not finding it. Noting that although the state regulated the schools in many ways, imposed few conditions on the school's personnel policies, the district court concluded the nexus between the school and the state was not sufficiently close. So this action could be considered the action of the Commonwealth of Massachusetts. Okay. But 9 days earlier, a different judge of the District Court of the District of Massachusetts reached a contrary conclusion on the same question brought by the other 5 petitioners. So we have 2 different cases happening in parallel. We have this person who filed suit, and we have the 5 other people who filed suit. They're being heard by 2 different judges in 2 different cases, and they're decided at roughly the same time. So your case comes out one way, and the other case comes out the other way. So that opinion stressed the school's dependency on public funding and regulation through the public entities. It also noticed that although education was not a uniquely public function, it's primarily public, and Brookline does not maintain a school to serve the maladjusted adolescents with drug, alcohol, or emotional problems. Okay, fair enough. So it's saying, look, among other things, like, you, the state, have agreed to educate people. You've taken on that burden, and that would apply to everybody. And special needs people need to be treated differently. That's perfectly cool. So we understand that. You don't want to do it yourself in creating a public school environment, to do that. That's understandable. You want to hire specialists to do it for you, and hire them to do an administrative for you. That seems reasonable, but, that fast makes it state action. It's something you would do yourself. It's something you may have an obligation to do yourself. So the fact that you are doing it for some students means you might have to do it for all students, creating an obligation. And therefore, this is actually state action because of that connection. So the 2 district courts come out differently. Both seem reasonable on their face. What's next? The Court of Appeals for the 4th Circuit consolidated the 2 actions. Yeah, so this happens quite frequently in these kinds of situations. You have 2 cases. They are close enough, to varying degrees of close enough. And so the Court of Appeals says, okay, I'm consolidating these. They're 2 different cases brought by 2 different parties and 2 different things, but they're the same underlying facts, same underlying issues, right? Same underlying stuff. So congratulations, you're now part of the same case. We see that happen fairly frequently. It's not uncommon. So that's what they do. They consolidate. It noted that school funding regulation function shows it has a close relationship with the state. However, it stressed that the school is managed by a private board and the state has relatively little involvement in the personnel matters. It concluded that the school, although regulated by the state, was not dominated by the state, especially with respect to the decisions involving discharge of personnel. So yeah, that totally makes sense. And so the Court of Appeals for the First Circuit is looking at this with a little bit more precision, because it is saying that it depends exactly what's happening. Some of what's happening at the school may be state action, and some of it may not be action. And that kind of makes sense, because you're looking to exactly what's happening in exactly what context. So some of what the school is doing might actually be state action. But at this precise moment, what we're concerned about is the personnel action, that component of it. So like, even if the teaching of the children is a state action issue, that's not what we're talking about. We're talking about the personnel action. And so some of this can be segregated and separated. And so with respect to that element, at least, there's not enough state connection. So we don't have to say it's state action for all purposes. We only look to the individual purposes and not this purpose. And that makes sense. Like, even if Facebook was acting as a state actor when it took down the posts relating to protests, even if that's true, it doesn't make Facebook a state actor for all purposes. That's not how it works. So Facebook might be a state actor for that action, depending exactly what those articles meant when they talked about consultation, right? But even if that's true, even if Facebook actually did violate the First Amendment because it strayed too close for that, it doesn't apply everywhere else. So that's what they're talking about, and that makes sense under the case law. The ultimate issue in deciding whether a person, entity, whatever, is subject to suit under 1983 is the same question posed in cases arising under the 14th Amendment. Is the alleged infringement fairly attributable to the state? Is this state action? The core issue presented in this case is not whether the petitioners were discharged because of their speech, without adequate due process, but whether the school's action is state action. Yeah, if it's private action, none of this matters. So the core issue isn't, did you do it because of speech? Did you do it without due process? That's not the core issue. The core issue, does any of this apply to you? That's the core issue. If the action is not state action, the inquiry ends. Yeah, private entities can do what they like. So, if it's not a state entity, then we don't have to ask any further questions. Okay. In Bloom versus Yartsky, the Supreme Court analyzed the state action requirement of the 14th Amendment in the context of nursing homes. The court considered whether certain nursing homes were state actions for the purpose of determining whether decisions regarding transfer of patients could be fairly attributable to the state. The court held that a state normally can held be responsible for a private decision only when it has exercised coercive power or has provided such significant encouragement, either overt or covert, the choice must in law be deemed to that of the state. So we're looking for something fairly close. Nursing homes, like the school, depend on the states for funds. The states subsidize the operating income of capital costs of nursing homes and pay for medical expenses on more than 90%. So like the school, the nursing homes are getting their funding 90% plus from the government, right? So that's similar. The Court of Appeals concluded the fact that virtually all the school's income was derived from the government funding was the strongest factor. But in our prior case, Bloom, we held that similar dependence of the nursing homes did not make the acts of those physicians and nursing home administrators acts of the state. And we conclude that schools' recipients of public funds does not make that decision acts of the state. So mere funding alone is not enough. And that makes sense, right? To make this easy, I, the state government, want to build a highway. I approach a business that is a construction company. I say, hey, construction company, I have $100 million. Would you like to build me a highway? And they say, yes, I would. So I give them $100 million. I'm totally financing the project, right? And then they do whatever they do. Are those hiring decisions now action because I paid for the underlying thing? No, that doesn't make sense. So just because I paid you to do a service and you did a service for me doesn't make everything you do state action. That seems to make sense. The school, like nursing homes, is not fundamentally different from many private corporations whose business depends primarily on contracts to build roads, bridges, dams, ships, or submarines for the government. Yeah, same thing, right? Acts of these private contractors not become acts of the government by reasoning of their significant or even total engagement in performance of public contracts. So just because the government's paying for it, it's not going to trip this. If it did, it would trip at all these places here. That doesn't make sense. The school is also analogous to a public defender found not to be a state actor in Polk County versus Dodson. There, we concluded that although the state paid the public defender, the relationship with the client was identical to that existing between any lawyer and any client. And that totally makes sense. And for whatever it's worth, under the ethics rules that apply to attorneys, attorneys can accept money for a client from a third party. So like you want to hire me to be your lawyer, you don't have any money, but someone else does. And whoever this someone else is, your friend, your parent, your GoFundMe, whatever, right? So they want to pay me to be your attorney. So they're going to provide the financing. Great. Now, the only caveat here is that I need to make it clear to everyone, both the client and this person who's paying, that I represent the client. Period. End of discussion. You're giving me money is super, super interesting, but it gives you exactly zero control over the case. None. Zero. All decisions are between me and the client, period. So, if your father or your whomever wants to give me money to defend that case, that's super, super interesting and really thankful. I'm super grateful and all. But my duty is to the client, my obligations to the client, and me and the client together are making decisions. You have zero part of the decision-making process. So that's the only thing I have to make clear. And so they're saying it's exactly the same whether or not you're being paid by the state or anyone else. Yeah. So in the case of a public defender, right, they're being paid by a third party, the state, right? So the rule is exactly the same for a public defender as it would be for any party, right? If any attorney being paid by a third party, the third party doesn't control. So the fact the state is giving the public defender money is super, super interesting, but the state has zero control. They cannot tell the attorney what to do. The relationship is between the attorney and the client, period. So thank you for the money and all, but, it doesn't make me a state actor. It doesn't make me, in control of whoever's giving me money. Fair enough. A second factor considered in the nursing home case was the extensive regulation of nursing homes by the state, as you'd probably expect. The court relied on Jackson, where we held that state regulation, even if extensive and detailed, does not make a utilities actions state action. Fair enough. The state is the one paying for it. They want to say the terms under which they're paying for it. They want to regulate it. It's like, it's our money. We want it spent this particular way. That makes sense. Why that's not state action. The third factor asserts to show the school is a state actor that performs a public function. However, our holdings have made clear the relevant question is not whether a private group is simply performing a public function. We've held the question is whether a function performed is traditionally the exclusive prerogative of the state. And yeah, so whether or not it's exclusively the state or not is a huge issue here, yes. So, private entities can do a lot of what the state is doing. So that doesn't make it inherently state action. It's whether it's traditionally exclusively or not, yeah. We hold petitioners have not stated claim for relief, and accordingly the judgment is affirmed. So that is our end of the coverage of the case of Randall Baker versus Cohn, which was sponsored by someone on this channel. Thank you again. So in this case, we learned a little bit about some things that make state action and not state action. So we learned that the state paying for it isn't enough. We learned the state regulating it isn't enough, requires a little bit more. And that totally makes sense because the state may want to buy things and may want to state why and how they're built. If the state is building a road, it's probably going to set the conditions for what the road looks like and a whole bunch of regulations dealing with that. And if it's a school or if it's a nursing home or a whole bunch of stuff, it's their money and they're going to say, well, we want it done this particular way. So that makes sense why that isn't state action. So that isn't enough to state action. We're looking for a little bit more than that. And that's very interesting. And that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.